Do you see my screen?
Yes.
The trademark chapter starts here. Okay, yesterday we looked a little bit at the copyrights, and now let's look at the trademark as a first right that belongs to the group of industrial property rights, as we call them, a bunch of rights. As I said yesterday, industrial property rights are more unlike each other between themselves than copyright, where we already have quite big differences, because between authors' rights and the rights of performing artists, there are huge differences, for instance. And those between trademark and patents, for instance, are even bigger. So let's see what they are. The root of what trademark is best understood actually through semantics and semiology. So the science of meaning, of words, of notions. And from there comes the term signifier. So we describe trademark as a signifier in communication with consumers, where it helps consumers identify product, services, and their sources. That is traditional role of trademark. And mind you, again, I will use the Adriatic example here, where I sit on the Brač Island. You know, around there are multiple underwater archaeological sites full of amphorae and oil lamps. And, you know, funny enough, from the Roman times, they all bear trademarks. They have signs that denote their origin. Just like the bricks and the roof tiles that the Romans were using, they already had trademarks. Even in more ancient civilizations like Greek or Egyptian, we have the same function of signs being used to denote the origin, and then therefore you would know a presumed quality, you know, of, for instance, of clay that was used by this producer at a certain location. So we had this trademarks really almost as a sign of you know, as a part of our civilization, much before we had intellectual property law. And when intellectual property developed, so the trademark was really fixed in this original sense, and then later it developed into what we understand today as brand. And I just want to say one thing. You know, in Italian we say marchio. In Croatian we say žig, which means stamp. And most of Croatians, because we don't have intellectual property education in our secondary education, and most of the university also wouldn't have them, so people mix this žig with the stamp, the real stamp that, you know, that you used to use in the offices in the past to sign the documents. But why do Croatians use term žig, which sounds confusing? That is because best understood if we look what the term brand means. And brand, what does it mean? You have heard about branding iron. This is this iron that you heat up in order to stamp a cow or another animal. Here on Brač, it's sheep. But, you know, so it burns the sign into the hide of an animal. And that's where the word brand comes from. So actually, Croatia is one of the few countries in the world that call marchio, mark, trademark, that we call it brand by different word, because we say žigosati kravu, right? That's to stamp a cow. And therefore that's what we have as a root of the name of this right in Croatia. And once we have a trademark and brand, then we have the general awareness of the population, the possibility to recognize it, the possibility to choose, and then to build loyalty to this choice if it was a right choice. So in modern speech, we actually in modern marketing, even more than speech, we understand brand as an overall category, which is really the object of protection. And again, GIG or markio or trademark will be just a container for this intangible good. But strictly legally, what is protected as object of trademark is not really brand. It is something that is called goodwill. This is, for instance, when most of our civilization, our societies don't necessarily understand this, including our judges. They think when they protect a trademark that they need to protect the sign that is object of trademark protection. But what they should be protecting and what is the value, the liquid in the container of trademark is goodwill. And what is goodwill? Goodwill is a monetary value of the perception that consumers have of that sign. So it's an estimate of how valuable is the perception that consumers have of the protected sign. And this is where it comes that Apple has a value of $300 billion that's the value of perception of the portfolio of all the signs which they have, like iPad, Apple Watch, Apple Music, blah, blah, so on, So all this together amounts to 300 billion or 200 billion dollars as value. And that is the object of legal protection of trademarks. So it's goodwill. But goodwill, of course, increases with the value of brand, because when we are more loyal to a brand, and brand has dozens of definitions, some of them pointing to the choice of lifestyle. For instance, you choose a certain lifestyle when you become loyal to a brand, and this is all connected. So keep in mind that when you protect a trademark, you will aim to develop a brand. But what is the value for you as the founder, as the holder of that trademark right, is the goodwill, and that's what should be protected. Again, to make things even more confusing, we have in bookkeeping, we have term goodwill, which is not identical with the goodwill of the concept is the same, but they talk about the goodwill of the company, and it's broader and different in some. This is also causing additional confusion. So with the trademark, we protect 2- and 3-dimensional shapes, colors, combinations of shapes, combination of colors and shapes, and so on. But in the second half of the 20th century, by the end of the last century, we started extending this protection to sounds, to smells even. I'm not sure where the noise comes from and whether all hear it. Okay, now it stopped. If that person can please mute. So thank you. So we protect by trademarks today sounds, smells, multimedia, like video clips and sounds combined. And then, for instance, I mentioned this tactility often because that was a great example. It was an Italian, actually, application for a European trademark where a toy manufacturer would apply to whichever toys they would have. They would apply like a pendulum that was like what's the English word for this? Sweet, the material that feels like rich and thick. So they would have like a sweet button applied to any of their toys which they were selling, and they sought a protection for that, and they didn't get it, which I thought was really a shame, because it is an excellent trademark, a tactile trademark, but the European Patent Office at that time didn't know how to publish this trademark, and trademarks need to be published in order to be protected. So there was no way you can print or put on internet a tactile, in order for mark to be communicated to the public, and therefore it was rejected. And I always work on this with students, because it's still now 20 years or 20 plus years even probably after that will still be a problem, yet our modern trademarks are really getting more and more non-traditional. We don't need novelty for trademark registration. So you can register a trademark that has been used for a number of years. It doesn't have to be new. And if someone applies before the rightful owner in bad faith, then that always causes a problem, and it will be resolved different in different countries, and it complicates things. Now, European Union was in last 10 years harmonizing the bad faith. So at least within Europe, we are getting small progress, but this is still a big problem all over the world, because what is considered the bad faith, this trademark hijacking, which happens a lot, for instance, in China. You need to know that China protects now more than 7 million trademarks a year. So while I am talking here in our first block, there will be 20,000 trademarks filed in China during today. I mean, so they protect everything, and whatever seems interesting for them, even someone else's trademarks gets protected in China by someone who then tries to monetize on that. So this type of hijacking would be resolved with bad faith, and there are big negotiations between the EU and China about how bad faith, and China did actually update their laws, but now the interpretation of what is bad faith, again, they consider bad faith only the use in China. So if a European owner did not use it in China before the local registrants, there will be no bad faith, although it is abundantly clear that the local registrant actually saw the European trademark being used on the other markets. So we are still kind of struggling to resolve this. So as I mentioned yesterday, we have formal protection by registration, and we have informal non-registered trademarks, which I said were possible in Italy, unlike many other European countries. And you would have a trademark that was not registered. In most of the European countries, it would not be a trademark, it would be a sign that has a certain level of protection. So it's similar but different. And again, I don't know if this has been changed in Italy with the European harmonization efforts. I would think that it might have been over the last 10 years. So we have the one thing that we should mention, and we should be actually very proud of that as Europeans. We have introduced the only global supranational IP rights. And in Europe, these two supranational IP rights are trademark and design. So we have European trademark and European design. It's the only supranational in the world. I will explain you later. There are systems in which you can apply at the single place, but you will get national rights at the end of process. With European Union, we have a European trademark that you apply in Alicante, you get a single right for 27 countries. So that is a sensational achievement. It's changed the Paris and Berne conventions, which I was mentioning yesterday, that are normally based on the national jurisdictions, and this is because we need to do that. Many people don't know that European patent is not a European Union instrument. I will talk about that, but now it suffices that I say that European patent has members such as Turkey, Norway, Iceland, San Marino, Monaco, who are Liechtenstein, who are not European Union countries, and it's the European Patent Convention, which is basis for this, is not a European Union instrument. European Union was not successful in building up the supranational patent, and we will talk about that later when we get into patents. But we do have European Union trademark. Trademarks traditionally last 10 years, and you can extend them as long as it makes sense, economical for you to pay the protection. And there are indeed trademarks. One of the longest European trademarks is the Bass beer, the UK brewery who protected the Red Triangle already, I think, at the beginning of 19th century or something like that. And you see, they extend for all this period because they keep using it. The other example is Coca-Cola that protected, I think, the word Coca-Cola at the beginning of 20th century and is extending its validity over in this 10-year periods. And one last thing that I want to mention here is that when you protect the sign, you did not protect the copyright over the design. So when you acquire as a startup, for instance, a logo for your company, you need to make an agreement with the designer where you transfer copyrights to yourself and acquire the right to apply that copyright with that copyright in trademark protection. And even if you apply for the protection, but someone else has a copyright on it, that person can oppose your trademark application or seek its cancellation. So keep in mind that there are two rights actually involved when you have a device. This is called a device trademark. When you have a graphical, design of a logo, then there will be two rights running in parallel: copyright and trademark. And I mentioned Coca-Cola because it is indeed one of the longest, trademark and most famous in the world. But keep in mind, you see that they have protected all these possible shapes that they use. So first goes the words, the Coca-Cola Company, which is different than the name of the product, which is Coca-Cola. Then they have the logo, which they protected just in the shape, and then the color combination plus the logo. Also, please note that they are very consistent in using the dash between the word Coca-Cola, and you will never see, if you see that there is no dash, this means it is a counterfeit or something. This is not the Coca-Cola Company. They will consistently use the Coca-Cola as a trademark. Now, if we would have more time, we would here do a little exercise, which we will skip. And this is, regarding the descriptive elements, because you know that coca refers to coca leaves and cola refers to cola nut, which is a digestive. And, the original trademark was in a way descriptive, which makes it weaker and less easy to protect. But this trademark became so famous that it is considered one of the highly reputable trademarks. And after all, they don't use coca leaf, at least not in the refined form in the beverage. The further examples, you see the Dove for ice creams. That's the owner is Mars Incorporated. There is a famous Croatian brand that's a kind of spice combination plus MSG as additive for food, but has a lot of vegetables in it and was traditionally very popular. Then we have the swoosh by Nike, which is also became one of the most famous trademarks, and is a good example of how before they were using the word Nike together with this check mark sign or whatever would they call it. Of course, the name, as I said, is swoosh, and you have now swoosh used completely independently of any word, and is also one of the strongest trademarks in the world. Then we have down there some traditionally very strong industries which today lost a lot of value, because the fossil fuel industry is really under pressure, as you would know also as oceanographers, and the problem that's behind it. So these two signs were very valuable and popular, but today they are somewhat threatened. And even the second sign by BP, British Petroleum, was even a redesign where they have used their traditional British racing green color and then developed it into something more green in the sense of ecologically kind of connotation. And obviously, this is what we call greenwashing today. At the time when they did it, it was a legitimate move to refresh their brand. But again, I think that even at that time, 20 years or 30 years ago, when was that, they could not imagine the backlash against the fossil fuel industries that we have today. And then last, I would ask you who's that, and most of you would know that this is a Milka chocolate, and that is a color trademark, a pure color trademark. So the color per se is protected for that, for chocolates, in the name of its rights holders. I don't know even who's that, Unilever or Nestle, no, Nestle. Yeah, so that is also something that traditionally was not being recognized as a trademark. It was considered that colors are a limited resource, and that we would run out of colors if we would grant protection to rights owners for that. But in the meantime, we realized with the Pantone coding and everything, there is an infinite almost number of colors, and there is a huge number of goods, different goods. So if you apply, there is so many color combinations. So if you can prove really that your products are understood by your consumers as coming from you as a source, just by indicating the color, you have protection. And many companies did that. Mars did that with Whiskas, pet food, which has some kind of violet color, not very different, but sufficiently different from Milka to be protected. There is I don't know, Reckitt Benckiser has color trademarks. UPS has the golden brown, or bronze, how they call this brown as a color, and so on and so forth. There are many. So the trademark has a semantic significance, which I said before. It has a symbolic significance, which I tackled also in the introduction, where consumers, shareholders, and employees will have a different set of values associated with that signs. It has economic, like in bookkeeping and tax, because you can deduct taxes, you can pay royalties in such a way on intercompany basis that you optimize your taxes. Then it has a legal significance, because you can enforce it in administrative, civil, criminal, and misdemeanor proceedings, which we will talk about tomorrow. And in the end, it has a civilizational significance because our civilization is really defined by brands and trademarks in a way, for good or bad. You know, I used to be, you know, a long head. I am a baby boomer by generational affiliation, and I have this hippie anti-consumerist attitude. In spite of spending my life with brands, I have my thoughts about importance and how they should be used. I'm happy to discuss that if anyone will want later on. And if you have questions, please, again, I remind you, you can interrupt me and ask the questions. So when we look at the scope of protection, you know, this is what I have mentioned as being goodwill, but we look the scope of protection in relation to the sign and the products and services for which it is protected. These products and services come from a list called the Nice Convention list, where you have 45 classes of goods and services, and you can protect the sign for furniture or for food or for both. You know, and the signs, the scope of protection be limited only to those that you have claimed for. So if you have a food protection, you will not have furniture protection unless your trademark is highly reputable, such as the Coca-Cola, which is in most jurisdictions would be considered a trademark of great renown, and there the protection would extend beyond the scope of the goods and services class in which it was applied for. I'm not going to go into this type of detail, because again, we could have 3 days just about trademarks to understand really how it works. But just as a taste of what it is, you know, and when you go for protection, when you apply for protection, then you need to understand this better. And this is one thing that in our countries, sometimes the entrepreneurs will go and protect on their own. You know, they will try to save some money by not going to a trademark agent, and then very often they will have a wrong scope as a result. They will not understand fully how it works. Although, you know, companies that learn this once, it's not that complicated. So the many companies will do, you know, it's a very justified step to bring this knowledge in-house and then do your protection on your own. I'm not going to talk about the dilution, but the trademarks and mental linking, but this is something that's added layer of complexity on traditional trademarks. We have realized that there are very subtle psychological processes attached to a certain type of use of trademarks, and when a competitor uses something in these subtle ways, we have extended trademark protection to that, and the European Union did this as well, and the US did, and so on. So this just is, as I said, added complexity on something that was already complex, because our societies did not ever really fully adopt intangible assets as something self-understanding, you know. And again, you know, when you look, as I had the privilege of studying and working in the US, and then when I came to Europe, you see a huge difference. You know, in the US, even the small businesses understand trademarks to a higher degree than European businesses. So this comes out of this longer use of these legal tools than us on a larger scale, and probably also as everything in the US is somehow more merciless, if you will. You know, the market is merciless there, and they have learned, they have burned their fingers already so many times that everyone knows that they need to do this protection, while we are a little bit more comfortable in Europe. Yes, what will I spoke about evaluation, and I'm not going into these methods unless someone really wants badly to know what are the methods to evaluate them. I'm skipping that because I already mentioned the possibility of evaluating and putting it on a balance sheet. I will just mention that most often this is done through transactional value, and that's the one of the three methods of evaluation, and that is what helps us determine. This means the average of the past transactions will be used as a marker, a benchmark for value of your trademarks when it will be evaluated. Here on this slide, I want to single out the second bullet, and this is something that really truly distinguishes mature economies, sophisticated enough, you know, to increase the protection by developing elements of distinction in whichever field they operate. So, you know, if you can't get your patent on an invention of the product, then you will try to patent an invention regarding the packaging of that product. So you will develop packaging in such a way that it will be novel, you know. Same thing with trademarks. You will develop identities of your products in such a way that they are highly distinctive. You know, in Croatia, there's a weakness in entrepreneurial culture when everyone thinks, all the entrepreneurs traditionally would think, oh, we were better off if we monopolized the generic term. You know, like one Croatian bank got a domain name, not a trademark, but it's the same example, banka.hr. But it's totally worthless because banka.hr, what is this? No one knows what it is, you know? So they thought that they had a big victory with that, but actually they got a worthless signifier, you know, because there was no distinction. So building the distinctiveness into a sign is something that mature market players will do naturally without advice from a lawyer, or, you know, they will just do it that way. And that's the path we need to help our small and medium enterprises in Europe to move into this area where this comes naturally as they develop their identities. Yes, I think also that I made plainly clear, you know, that our civilization being marked by trademarks has many elements that you know, that should be taken care of in order for this relation between society and trademark to work well. And when an entrepreneur starts registering the company, SRL or DOO, you know, that's the first moment where you get to choose the identity. So even when you start a company registration, when you incorporate a startup, then you already face this choice of what will be a good element of identity. And then you need resources in terms of employees who will take care about that, or budget to pay the advisors externally. You need to acquire knowledge by training, by networking, lobbying, you know, to get this properly aligned. your market behavior and your protection sequences as a company will change as a consequence. That's the difference between transitional company and a fully mature market company that so many Croatian companies are struggling with. And over the last 3-4 years, we have a huge breakthrough, you know, where companies started understanding this because they took advice, because they just launched into this type of behavior. And we already see the results, you know, this fact that the Croatian economy created 2 unicorns, more than 1 billion companies in the year of pandemic is a clear sign of that shift that happened in the Croatian economy that we almost can't believe ourselves, and which we certainly did not expect, but the breakthrough happened. And again, this is through help of European Union, actually, because it would be much slower or impossible to achieve without being part of the huge market. Yes, costs, I have been talking about it. Let's look quickly at industrial design. Industrial design protects only shapes, and that can be 2-dimensional or 3-dimensional. I have here emphasized that it also has a role of communicating with consumers, and it also has an overlap with trademark in identification of products and services. And just think of Coca-Cola bottle. You know, Coca-Cola bottle is a 3-dimensional shape which was born out of a design effort, and it became, after all the design protection expired, it became a 3-dimensional trademark because it is so closely associated with identifying the source of the product. The other way around, it wouldn't work. You can't have first a trademark and then industrial design, because industrial design needs to be novel, while trademark does not. So you can do that. Things are even more complicated. I will just mention, you know, that in some countries you cannot accumulate. There is no cumulative protection of IP rights. So you will need to choose between trademark, design, or copyright when any of the 3 could apply. In Croatia, that's not the case, and we can cumulate. That's called the preemption in common law, and one protection protects preemption, while in Croatia this is not the case, and we can protect in parallel with all the rights. Some of the big users are textiles, you know, automotive industries, and so on. So when we, as I said, it must be novel shape in order to qualify for protection, but unlike patents, they are not examined for novelty. They are just published, and the older holder of a right of a similar design would have to object to the publication. So we will talk about how that works probably later. Probably we will not talk about that, but just that you know. So there is no, it must be new, but it's not examined for the novelty. It's left to the other rights holders, the prior rights holders, to object or to cancel the shape later on during the life of design. We are talking about author, same like in the copyright. So you see that there's an element of overlap with copyright. The person who created the shape is called the author. It is formal, registration is required. So just like trademark, we go to a patent office, patent and trademark office to seek, to apply for design right, and it is moderately complex in the sense that it's closer to trademark than to the patent, which is more complex. In the EU, which has the most modern design protection mechanism, legal mechanism in the world, which was a success. It is one of the successes of the EU. It was questioned a lot when it happened. I don't know, it happened probably now 20 years ago or something, even I don't remember when. And then we introduced this 5 + 5 + 5 years of duration, up to 25 years, when you cannot extend it anymore after 25 years. We also have something that is in Europe that is called unregistered design, which is used by industries that have very short product cycles, such as footwear, for instance. Footwear is sold for 3 months during one season, and for them it is too expensive to apply for design protection, so they can invoke this unregistered EU design. This is not, to me, very clear. I did not have really cases with that, but on the bigger markets there will be cases that will tell us how to what are the limits of that design. And what is beneficial is the possibility to protect multiple designs by a single application, up to 100 in most of jurisdictions. So you can cram really different designs, almost unrelated, but you can't go with the unrelated designs in a single application, but the shapes can be unrelated. And this is a very, very beneficial. And here are some examples. We see the new Beetle was registered. Then even the retail spaces. Here we have 2 shell designs. This is on the upper right is a design of the space, of the retail space in a gas station by Shell. And you see that there are elements of lighting that are very important, obviously, for them. And there are certain features that will repeat in any store that they will open, such as, I don't know, what's this yellow stripe behind in the bottom of the space. You know, obviously that will be something that they will repeat, and probably the layout of the shelves in the space, and I don't even know what they had in mind. And then there is the design of a two-dimensional, that's the 3D, this upper, and then the two-dimensional, you see the credit card or the loyalty card, which they designed, is protected, although it would be covered in the entire European Union, probably also by copyright to a degree, but because it is a map of Europe, you know, there's a low level of copyright there, and they applied for a design or to strengthen their right. You see, doing things in parallel. No? And then there's here the example of the first iPod, even before the iPhone, whose shape surface was protected. And as you know, the Apple-Samsung battle 5-10 years ago was about designs, actually. You know, and I don't know how many European consumers realized that it's not a patent or trademark battle. It was a design battle largely. So you see, they have claimed, Apple has claimed the rounded corners as a design feature. And that's what they were. And you can see really here on the first iPod, the rounded corners that were later on used by all iPhones. So you have some kind of a different designs. You see the packaging, the glass container on the upper right. Then there's some kind of a chair which looks like something rustical or rural design based on some, and then there is again this shop. This is probably part of the same design application as the upper photo where you see lightning, and here you see these yellow stripes. And then the examples about the Croatian football uniform, which was protected as a design in Croatia, but is actually not novel. And if it is novel, that's only for one season because we update this consistently. So it should be enforced very, very narrowly. And I can tell you that there were cases about trying to enforce this design, which were not really successful. So you cannot also, this is a national emblem because the checkers, the red and white checks on the surface are really part of the national emblem, which further narrows down the scope of protection. So it is all very, very questionable. And, you know, obviously in sports, there is a lot of money. So people will invest even in the low-level protection, or even, you know, even if they don't get it right, they will try to have an application pending to scare off people during a certain period of championship or whatever. These are tactics used by the right holders, you know, just playing with the applications, even for something that they suspect they will not get protected ultimately. So they are legitimate, but they, in my view, very often amount to the abuse of the system. This is done with the patents as well, and as we will be speaking about patents later, you know, I want you to know and understand that there is this issue of abusing of the IP system, and you need to be able, excuse me, to recognize it when you see it. So let's look at these related rights, which are not stricto sensu IP, but are really protecting elements of intangible assets which are very close or identical to intellectual property protectable. And I have mentioned already company name. This is for Croatians, really, where we say tvrtka. And that is, the tvrtka is not a company. It is a company name in the legal language. I don't know what would be that in Italian. Would it be ditta or something, which is a company name in itself? And in Croatian we use it interchangeably. We use tvrtka to say company, which is not so. And this is one of the things I wanted to mention here. It is automatic with incorporation. And then in Croatia, there was a problem that you would get tvrtka on a territory of a particular court of registration of a company, but not the territory on the entire country. This is changing as we unify the databases, but we do have a lot of companies with the same company name. You know, one in Bjelovar, other in Zagreb, and the third in Dubrovnik. And the names are identical. So this is a problem with company names protection in Croatia, and in various countries it will be resolved in various ways. So it is uneven and not as harmonized as we would hope it would be. But again, it was harmonized early in the Paris Convention, and therefore it is comparable from country to country, but it will not be as harmonized as trademarks are nowadays. Again, the cost is included in the cost of incorporation. So unless you hire marketing people to develop your identity with which you will incorporate, then the costs will be even less than moderate. You know, it's included in the cost of incorporation. Then we have labor law that deals with various aspects of IP protection, and primarily, you know, this will be regarding inventions, because it may determine from country to country, again, will be different, to whom does an employee's invention belong? Is it automatically to the employer or not? Italy has extremely developed labor law in respect of intellectual property. And when I was practicing in Milan back in the early 90s, I have learned already, that depending on whose computer it was, will be decisive to determine if, look at the criteria that will be used. You will look whether an employee was working on that invention as a part of a task given by employer or outside of it. Then, was he working during the working hours or after working hours? Was he or she working on its own computer or on a company computer? And things like that will be used to measure to whom does an invention belong. So this is not, at least at that point, it was not in Italian law, but the courts found out many elements that will be used to determine to whom invention belongs. This is very often critical for exploitation of an invention, because if you don't have a full title on the invention, you cannot monetize it. And if you start a litigation with between an employer and an employee when you need to exploit the invention, this is not really good for investors, and investors will withdraw. So this must be resolved appropriately in time before, ideally before the exploitation is really commencing. Then you will have all kinds of other innovations that will not be patentable. We call them in former Yugoslav countries technical improvements, which will be an improvement on existing procedures, but will not really amount to a degree of novelty or inventive step sufficient for a patent protection. And then authors' works, and for instance, to show, when Croatia modernized its copyright protection in 2003 in preparations for joining the European Union, we have changed from Yugoslav concept of employer acquiring copyright over the works of employees to a different concept whereby the employer must transfer the rights on employees' work to the employer. So for a decade, many employers in Croatia didn't realize that and did not make agreements with their employees who were retaining rights on their copyrights. And this now became, well accepted, and it's not an issue anymore. But and then there was exemption in 2003 when we modernized, and there was an exemption, and we did cover software as belonging to the employer. So in respect of software works, there was always protection, in favor of the employer. Then the other thing is that is also one of misunderstandings in Croatian entrepreneurial conditions is that people confuse non-compete clauses with confidentiality. So while they will make non-compete clauses in labor agreements, they will forget the confidentiality clauses, non-disclosure and they will think that it's sufficient to have non-competition, and then they have a huge hole because later on former employee can use confidential information unless this was regulated. But let's not go through all the scenarios because that would take us really a lot of time. And here we see the importance of the bylaws. It is very important that companies bring this soft law, these internal regulations of how they want to resolve all these issues. because that will give courts the answer. And if the courts see that the company wanted to retain, they will decide different, than they would without it. And the intellectual property clauses in the contracts with employees, and separately from employees, the managers who may not be employees but will have a managerial management contracts, they need to have intellectual property clauses. It is extremely, extremely important for success of monetization of intellectual property created by a company. Yesterday, I have mentioned unfair competition. Again, this is not competition law. This is something regulating disloyal or dishonest market behavior and misappropriation of the added value that might be protected or protectable, but is not So here we have examples given by law, but normally the laws, and there is a EU directive, which is now probably, I don't know, 3 years old or whatever. It is that the member states needed to implement by now, I think. We will have a degree of harmonization in unfair competition. Among other things, they protect unregistered market identification signs, which I have mentioned before. It is also important because it's somewhat broader than intellectual property. For instance, in regulating advertising speech, this is easier to understand if you use American terminology. You have all heard about the First Amendment rights to free speech that America has. So the United States has protection of free speech, and then there is a different set of rules for what they call commercial speech. So when you look like that, then in Europe, we regulate advertising from the point of view of consumers. So it's slightly different, but essentially it's the same thing. Someone talking about their product. So it's a commercial speech. And there, the reputation of competitors should be respected. And it actually corresponds with the civil law protection of reputation of a corporation as an intangible asset. Then the newest development is data and privacy, which are closely related, and I'm not going to go into details. But what we need to understand that these new intangibles are not created through human creativity. So in the last 300 years, we were protecting intangibles based on human creativity. Now we have a harvested or even generated data. And how do we need to have a different legal regime for harvested from the generated data distinction? Meaning, if you generate the data or your machinery generates data, are you owner to a higher degree than if it would be harvested, by sensors that are somewhere outside of your environment? So it's a strange field in which we don't have clear answers yet. And with the Internet of Things and with the scientific work, after all, which you engage, where you harvest the data in the seas, it's really a question, and it turns out that it needs a very different protection than intellectual property, where humans claim ownership on this. It seems that there's an understanding that data protection would not benefit from ownership solutions. But let's leave this more legal philosophical issues aside. And let's just keep in mind that personal data and sensitive data will have special regimes, even higher level of protection, and there comes the GDPR that we all know, that was first seen as something very unnatural, yet in a short period of time of 3 years, because GDPR is now in force for 3 years, it became well accepted and actually very influential globally, and it's setting standards for the world far beyond the EU borders, such as South America is adopting the similar approach, and even in the clash with US, where EU was unfortunately on a very bad footing, because we did not create large companies owning huge amounts of data as US was successful in doing. So we are a little bit fighting from below here. Even with GDPR, you know, I can only speculate. I have nothing, you know, I even think that GDPR might have been an attempt to make a more even playing field, but it seems that it was a successful move, because now we will be entering a new round of negotiations with the US about building a new common data protection system, because our economies, the EU that is, and the US are highly integrated, and we have on both sides interest to harmonize this to a degree. And now, obviously, with this strong enforcement regime of GDPR, we need to think about the artificial intelligence, and how will this be regulated? Who will be overseeing this? Will this be regulatory agencies and so on? But let's not go into that. Let's look at the database right. It is something that is in most jurisdictions embedded in the copyright laws. It is a related right to copyright, but it's not copyright, because you don't have an author there. You actually don't have a work of art even. It is you have a right over something that you have collected by putting money or effort in. So it's a very low level value added, protecting investment, an economic category rather than creative category. And let's just say that this does not exclude additional database protection as a collection of copyrightable things. So if the thing in the database is copyrightable per se, then the choice of this will be protectable. And again, I don't want you to become IP lawyers, so I'm not going to insist in explaining all this, but just keep in mind that we have a database right which is for a low level of creativity or no creativity, a protection that is also an EU attempt, similar like the design right reform, you know, and it was also discussed and resisted in a way like GDPR, and it was not so well received, but because the EU Commission always, after 5 or 10 years after introduction of such rights, they do a review of what happened, and then it turned out that people still wanted to remain. So it is lingering around, and it can be used. And keep in mind that the data that you collect will be stored in a database over which you will have a separate IP right. That's what I think is important for me to tell you. Again, domain names are not IP in traditional sense, because they did not exist in the 19th century when the IP system was devised. We have them since late 90s or early 90s actually, when DARPA system was turned into internet, and we have into public internet. and we have noticed immediately that they are similar to trademarks in function because they serve as signifiers. They have a purely technical function of serving as the URLs, the internet addresses, but humans cannot remember numeric URLs, so they were converted into domain names and serve as signifiers. And then we have the GTLDs, that's the global top-level domains such as .com, .net, and then we have country code TLDs such as .hr, .et, .de, and .it, that is. They are, as I said, similar to trademark because in spite of the fact that they are actually denoting the true internet identity at the same time. But then what is the true trademark identity? One thing for humans, the other for machines, you know, so that's this double nature. And I'm skipping these nice stories about what was going on during the history of introduction of domain names. I have mentioned geographical indications yesterday, paramount for both Italy and Croatia. You know, Italy has example for the whole world in the success of using such geographical such geographical indications as, for instance, Parmigiano Reggiano or you know, Gorgonzola DOP or Prosecco. These are multi-million, multi-hundred million operations that rely very much on geographical indications. Also, not a child of EU, but very important for EU that was all the time pushing it in. Croatia very promptly realized its importance, and we are protecting, like, you know, like from 6 to 15 GIs a year to quite a great success. This is just in this part of Europe, in Southern Europe, you know, we have such a varietal, such a number of autochthonous varietals of the local recipes of this and that, that it converts into very important GIs. You know, my wife's Argentinian, as I mentioned yesterday, you know, and I have seen the abuses I lived in the US, you know, I have seen the abuses of GIs in the New World, and it started out of nostalgia, not out of the wish of you know, when Argentinians called the wine Marsala back in 140 years ago, they were not competing with with Sicilian Marsala. They just wanted something to remind them of the old country, no? And that's why they used it. Now they resist the EU claims, you know, to abandon this because that's part of their history in a different way than it is ours. Yet the negotiating power of the EU is really strong, and when we do bilateral or regional trade agreements, we usually force our ways. One thing, for instance, where we have a resistance is the Porto in port wine in Australia, which also has port traditionally, and they don't feel like they are competing with the Porto, but they have much, you know, weaker claim in that, and we'll see. I don't know if this has been resolved in the meantime. Champagne is very famous, and in the US, which also resists, US successfully resists the Parmesan. They don't want to stop using the Parmesan, but I think they stopped using champagne. So you will not find producers there that will call their sparkling wines champagne, which, by the way, are excellent. You know, I lived in California, and it's one of the best in the world, I have to say. The cool climate, North California and Oregon sparkling are some of the best in the world, definitely. And they can compete without calling themselves champagnes. You know, it's really, really excellent products. Then now we have a reform of non-agricultural, or introduction of non-agricultural. That's the new EU thing. We have developed very much the agricultural, and as I said, Croatia has a pug, cheese, the Lika lamb, the turkey from Zagorje, and that's I want to say just to our Italian friends here, you know, this is a curious story, because turkey from Zagorje has been recorded from the beginning of 16th century. So the turkey was brought by Columbus back to Genova, you know, in 1493 or wherever he came back from the US, from North America. And already like 10, 15 years after, you have turkey in Zagorje. And it really became like an autochthonous animal, and is today protected. And then there are potatoes from Lika, which I would like you to taste. And in Italy we have cipolla di Tropea, and I don't know, peperone di Carmagnola, which is not protected, but I think it's not protected, but should be certainly is that kind of a high quality product. Recently, we had Croatia and Slovenia. I'm not going into that detail, but there was a case about Teran or Terano wines, which, if there is anyone in Trieste, as I know there is, or from Friuli, you will know about Terano. And here Croatia prevailed in the general court, and Slovenia did not sue Commission to the ECJ, to the European Court of Justice. So Croatia finally prevailed in this, and we can call, it's a long story, so I will not go into that. Let me see. Yes, we can go into this exercise, if you will. So who will tell me? Okay, let's first, any questions at this point?
No questions, so it's clear, but just to signal that we had also problems in wine with the Tokaj in Friuli Venezia Giulia. That was a dispute with Hungary, and we lost the dispute, and we had to change the name of our wine. That is no longer Tokaj, but it is Friulano.
Yes, I'm very familiar with that. As I told you, I know almost all vineyards, and in Friuli we go for wine tasting just as we go to lunch to Trieste. We go, so I have been, even there were many names. I don't know if you know the late Stanko Radikon from Oslavia. He was one of these vini veri, you know, the producers of these orange wines, and he called it. Yes, he was. Yes, the orange wines. He called it Jakot, which is just the anagram of Tokaj, because he was Slovenian. Ethnically, this means the strong one. So people were trying to find out. But Italy was not alone. Alsace winemakers also lost this right at the same time, because they also had Tokaj in Alsace, and they couldn't use it anymore. So France also lost. Yes. We also have one unresolved between Croatia and Italy, which I hope will be negotiated, which is Prosecco Prošek. But the wine varietals are totally different, and Prosecco, as we know, is a sparkling wine, while Prošek is something like a Vinsanto. It's totally different, and produced in a very small quantities for centuries under this name, and Croatia did not register it with the EU, so we theoretically cannot produce that. This was because Croatian negotiations with EU were so long that we abandoned this because of the strength of Italian economy. We thought they will stop us for another 4 years if we don't drop this. So this was unfinished, but there were some talks between Consorzio di Prosecco and the Croatian Prosecco producers, which were interrupted. And now, during the pandemics, people had the time to think, and they are renewing the contacts to see how will this be resolved. Any other question or comment? If not, then my question is, what do you see here on the slide? What is this?
Strange bottle.
Mm-hmm. Indeed, it is a bottle. And why is it strange?
Yeah, the bottom where you have the worst part of the wine that concentrates, and it actually I'm not an expert, so I don't know why it has this shape, to be honest.
But you know, coming from a wine country, you went the right way. You know, you see the bottom, and indeed, this serves to collect the deposit.
The deposit, yes.
Yes. So the sediment of the wine, which tells us what? So this tells us, first, this is a wine bottle. This is not necessarily an olive oil bottle. And we can see also by the shape of the bottle shoulders, which have the shape of the French Bordeaux bottle, that's a wine bottle. So what essentially happens here, it also, by the color of the glass and by the shape, we see that it is a red wine bottle. So what is this strange shape at the bottom then? It has something to do with the deposit, with the sediment. So I will reveal you that this is not a design feature. It has a functionality. So it is a patent feature, at least patentable feature. And it indeed serves as a second shoulder, because the high shoulder on the bottle here, these are shoulders, no? The high shoulder serves for tannic wines, the wines that have a lot of tannins, to collect the sediment here. When you pour it, the sediment stays here. If you have low tannin wines, such as Burgundy wines in France, you have a low shoulder. It goes like this. It goes like this. It doesn't have this angle here because it doesn't have to collect as many tannins. So this, for highly tannic wines, doubles this function because there will be even less deposit, and it allows the bottles to be stored horizontally, or at least not stored, but aged horizontally, vertically, I apologize, so to save the place on the racks. And this has been, you know, this product is 3,000 years old. We had some kind of glass containers even in Greece, you know. So how do you innovate on a 3,000 years old product? And you can, there are so much, you know, this emphasizes our way of creativity. Again, going back to what I said yesterday, we have, by adding knowledge, we go beyond the inspiration. In 19th century, we had this idea that creation is a result of inspiration of a gifted individual. Our understanding of creativity today is totally different. It is everyday activity of an individual with access to knowledge. And this is how we are able to produce this incredible amount of innovation that we do, because we use knowledge and create novel results, unexpected results. So you have something that has built-in technologies for 3,000 years, yet it is practically unlimited in development, and it will continue to be developed further. Let me just tell you that this glass product, on the high end, when we talk about the bottles that cost 500 euros and more, you know, for instance, one technology for identifying if this bottle is genuine is laser engravings in the glass. You know, so if that technology was developed for this bottle, it would be able to be patented. I don't know the history of glass laser engraving in glass. It's etching, some kind of laser etching in the wall of the bottle. But that would be protectable, just as this idea to have a functional solution to a problem of storing aging tonic wines. So what do you see here? What is here visible? What is, in other words, what is strange here?
The shape. No, not the shape. Actually, it's the
position.
The way bottles are, let's say, put in the box. And
exactly.
Why not straight?
Exactly. And to disappoint you, I don't know the answer. I will tell you that this is a feature of packaging designed to increase the durability of packaging and optimize the behavior of wine during the transport. So you see, that's what I said. Even if you don't have a patent on this shape that facilitates deposit, you can patent this transport feature for packaging, and you can protect the design of the shape of this bottle, of the carton. You know, when the carton is in three-dimensional form, it is protectable as such. If it is a two-dimensional, it is unfolded. You know, if you have the two-dimensional carton, again, it will have a shape that will be protectable, and you might consider protecting it. And this, I wanted to show you this to sensitize you to the possibility, you know, how to look at the products that are developed in order to protect them fully, this full coverage of protection. And then, of course, on this bottle, there is no brand. But when the brand is applied, it will be likely the brand of the winemaker and the brand of the whoever devised this box as well, because they will be licensing this shape to who will manufacture the boxes, and that who manufactures the boxes will possibly be required to indicate, possibly by a trademark, the one who devised this. And the one who devised this is a Martin Berasategui, the great Basque chef. He has a restaurant out of Donostia, out of San Sebastian, and has a consulting firm that developed this shape, improving the 3,000 years old bottle, so that it is even better for storing, transporting, and aging wines. So that's the end of this little exercise. Any questions? Otherwise, we are having a 15-minute break in you know, after this block. Are there any comments? Was there something that was not clear?
Everything clear.
Good.
No,
Others?
everything was clear. It's
Thank you.
well, the bottle is nicer inside from the inside than outside. Outside is quite horrible, but inside is really nice.
Yes, yes. I also think there's something wrong with the proportion of the bottle
Yeah,
when you.
exactly. It's not harmonious, let's say. Not
Yes,
there's
yes,
something strange, something.
yes. But you see, when we spoke about the evaluation of patents. Would someone who evaluates a patent take into account this strange unproportionality of the shape as a value of patent, or not? How do you measure these things? This patent might be successful, but might be unsuccessful for a variety of reasons, one of which can be this shape. And this can be decisive, So how do you measure these things, before they are on the market? So it's a big challenge, That's a good example for that also.
Yeah.
Yeah. Good. Other comments, please. If not, then I'll see you then in 15 minutes. Okay.
Okay.
Thank you. Bye-bye.
Goodbye.
Thank you. See you soon.
See you.
Hi and welcome back.
Hi.
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 Shall we start right now, huh? We have now to deal with patents, and that's in a way the right that we will look to somewhat greater detail than the others. I apologize to give you so many information this morning, partially because I didn't. I used yesterday these 10 minutes of the last instead of talking about trademarks, but I think that I hope at least that it was useful. So let's start with the patent. Patent is a right that is used to protect inventions. And what are inventions? I think that someone has, someone has. If I don't know who's that, but if you can mute, because I think there is echo from my voice from one of your computers. So please mute. Thank you. Thank you. So the inventions are essentially the answers to various problems, unresolved problems around us. And the technical result that comes from this answer is very often novel and therefore protectable under the patent law. But if we look broader as a human activity, you know, all of us who are working with inventors will know few things that have very little to do with the patent law or IP law. And one is, for instance, in the field of inventions, is that these answers to the questions that are around us are very often simultaneous. And what does that mean? I mean, it means that we as humans, we react to our surroundings. And when there's something new and unresolved, which we think we can resolve in a better way, then we start looking for the answers. And if we are scientists or engineers, you know, there will be many of us working at the same time, even without knowing each other, in providing our society with the answer to the problem that emerged. And that is the reason why very often, you know, independently, we have different inventions emerging at the same time or similar time. Patent right is one of the strongest intellectual property rights. It is exclusive. When we say that the right is exclusive, what we lawyers mean is that we can exclude others from performing under that right. So the exclusive rights of exploitation of an invention will mean that we can exclude everyone, including our competitors or any other entity, and thus have economic benefit through protection, giving us a market position that is otherwise not achievable. Indeed, what we say often, that a patent or any IP rights to a greater or lesser degree is actually a form of legalized monopoly. We effectively achieve a monopolistic position because it's only us who can practice an invention and we can exclude all others, which otherwise, without that, would be not truly legal, depending, monopolies are legal if they are achieved by legal means, but let's not go into that. This is the simplest way of achieving a monopoly. And what does Patent Act say? What is a description? And it says a patent is an exclusive right that protects a patent holder with regard to the economic exploitation of the invention, which is here the object, as the goodwill or the work of art, in case of copyright and trademark respectively, or 3D, 2D shape in the case of design. Here we have invention as the object. It is strengthening our market influence. It gives us a guarantee on more dynamic return on investment because we can recoup earlier because we are the only one who have the right to do that. We have ability to additionally monetize our solutions, technical solutions, by licensing or selling the technology. We will have a stronger position in any commercial negotiations that we will potentially be engaged with. And in, again, our civilization that values this, we will have an image towards the consumers and business partners and potential investors, shareholders and society as a whole, as a technologically savvy and, competitive business. So when I advise people looking, because many entrepreneurs will be looking for monopoly. They don't care about the patent itself, regretfully or not regretfully, that's just the fact. They want a monopoly. And they would come, these are people who don't understand normally patent system in depth. They just see that there's some right that they could grab and exclude others. They don't really have a full understanding of how you build a portfolio, how you build innovative activities in your company. They very often think that patent is about a single invention. They don't even plan to conduct a meaningful innovation program in their company. They don't understand that from a single patent, you don't get very far. You have to have your company organized along the lines of innovation. So this is much more complex than a simple entrepreneur sometimes imagines. And when such simple entrepreneur comes and wants to protect things, I discover that they usually think about protecting an idea, a business model, or something that they have barely developed, but they want to have a protection on it. So the idea is not protectable in any intellectual property. As I said yesterday and hinted to this problem, intellectual property is organized so to exclude ideas from protection. What you protect is a particular way how that idea will be practiced or expressed in copyright. So, if Shakespeare writes Romeo and Juliet yesterday, he would have copyright protection on it for the rest of his life, plus 70 years, because that's the duration of copyright in Europe. But someone else, any one of us here, we would be able to write a tragic story of two lovers escaping the straitjacket of their families who wanted to prevent their love from fulfilling in any other way by not using Shakespeare's words. The idea of that story is totally free, although Shakespeare has this strong copyright on the way how he told the story. So in patents, this is not exactly like this. And if someone achieves a solution to a functionality that serves as an answer to the purpose, he really might, if he is early or she early enough to write a broad patent. The Americans call this a pioneering patent. He can really achieve excluding others from achieving that type of functionality regardless of precise means. If you have a later patent, or if you drafted a patent poorly, then you will have a narrower exclusion zone, and you will be, somewhat more limited. But the patent theoretically can be very, very broad, and its strong exclusivity at the same time can give you an extraordinary strong position on the market. Again, I will repeat what I said yesterday, that the discoveries of natural law plus business methods are equally expressly excluded from patent protection. So when you make a discovery, you will publish it, but you will not be able to have a protection on it. However, if you have discovered, for instance, a method for achieving a result based on you, even if it is a discovery, and I'm talking from a first-hand experience because I'm working with an inventor who apparently made a revolutionary discovery. And he was successful in patenting a method for achieving the result based on this revolutionary discovery. We will see when this gets published, and how will it be peer reviewed and what will be the results. But everything indicates to a revolutionary discovery which cannot be protected. However, the method of doing this is protectable, and we have applied for a patent protection for it. So the fact that idea is not protectable does not mean that an invention does not start with an idea. We can now talk a lot what is an idea and really what is human creativity and how we come to the unexpected results. I mean, this is really an interesting discussion, but for the purposes of this training, we will just look at this chain of, having an idea, developing it, then coming to the invention, which needs to be an invention, it needs to be novel, and then possibly patenting it and going into economic exploitation. So this is what we will look a little bit in this remaining time today. And there are some industries that are very much relying on patenting in their business models. And first come to mind probably pharmaceuticals, and then biotech and life sciences now more recently. Then mechanical engineering, which is a strange animal because you have a lot of, Pythagoras already, set many mechanical principles and whatnot, So the improvement is always incremental there, and yet we still have a lot of mechanical engineering, unlike, for instance, in biotech, where our ancient ancestors did not have much principles because they couldn't observe them. Then shipbuilding is one specific boat particular to our both countries, a very mature industry, but still able to come with different solutions you know, as answers to the problems of all new technologies. You know, just the fact that we had a different strength of engines changed the hull of the ships, and we had million new and novel understandings of how the hull behaves in dynamics of fluid dynamics and things like that. And some of the solutions were patentable along the way. Electronics, food industry that keeps innovating at incredible pace. I am sticking to food industry here because, again, both of our countries, but whole humanity has always been using the most novel scientific understanding in agriculture, in producing food, you know. So this vertical farms, urban farms, this all will present problems, and there will be novel solutions for that. Not to speak about the GMO, which we chose to be very careful in the European Union, but which will nevertheless be used, you know, and is used already today in a more transparent ways in Europe, but will not be stopped. It will be used. So we have different fields with constant need for nuances. And the well-known problems for many countries is how to optimize science to business innovation transfer flow. I think that this project is partially motivated by European ambition to make a more successful transfer of innovation from science to businesses. And we really need to be aware that this is a European problem. And if you look Croatian scientific community, and I have had the chance to work a lot with that. I was working with Ministry in Science when the World Bank program still, 20 years ago, tried to help. It was actually Ruger Institute that was partner on this project, and then the first Innovation Transfer Office was a result of that project. And on many others, I worked with the Split University on trying to increase this. It's a European problem which is even more pronounced in the new member states of the European Union, and especially in the newest one, which is Croatia, and where we have to have make a pronounced effort to catch up and have, especially because in the case again of the both countries, we were historically very successful. I mean, very successful, important countries. There are tons of books about how. I mean, Italy, it's a fact, that from Renaissance, I mean, Italy actually was probably #1 in technology in the Renaissance, where some Croatian inventors, many of you will know that, for instance, parachute was taken by Leonardo from Faust Vrancic, from this part of the Adriatic coast. As a solution, and that there was a lot of exchange of technology in those days, but Balkans generally were underprivileged because of the Turkish invasion. So our resources went from innovation into defense, and and we totally shifted the resources on this. So it seems that we are less innovative because of this 500 years of trying to stop Turks. But when you look the number of inventions in 13th century, for instance, there's no difference between Western and Eastern Europe's in Europe in innovation. So this is now being remedied, and European Union certainly provides the chances that for the countries that were lagging for that long period of time, and which have shown in different outbursts of how can they innovate successfully. Again, I will just mention, you know, obvious example of Nikola Tesla, who actually built the second hydroelectric power plant in the world. 2 days after Niagara, the Kirka power plant was opened, and you know, and he put his invention to practice. Not to speak about the dispute about Marconi and Tesla, and who did first develop the concept of radio waves and so on. So we have a lot of you know particular inventions we can talk about and see how brilliant minds in this part of Mediterranean, which was traditionally always very strong. Speaking of Ruđer Bošković, who I intentionally use Italian pronunciation of Ruggero Bošković, who has streets in Milan and in Rome, was head of the Italian of the Milan Observatory before he moved to Paris and then to London, where he became member of the Royal Society. But he established optical laws of optics, you know, while he was still in Dubrovnik, you know, and who really is one of those who unite the two countries, because he lived both in Ragusa and in Milano. So we have a lot of inventors also who were using you know, this Mediterranean advantage that existed for so long, and which regretfully is not so pronounced anymore. It is really a shame that Southeastern Europe, and I will allow myself to say this, I have a Greek aunt, you know, I have strong ties to Spain as well because of my wife's Spanish language, and friends and all Argentinians who live in Spain, and not to speak of myself being so closely connected with Italy. You know, we have to work more on shaping up as modern societies, including the innovative capacities, where again, I'm not comparing Croatia to Italy because the resources are so asymmetrical, but still belonging to the same cultural, historical background, we can help each other with this. That's what I mean by contributing to own development and development of society. We cannot separate innovative capacity from the rest of our society. If we have corruption and organized crime, you know, we will not be innovative societies. And I can give you examples. I won't go into this, even in the scientific field, you know, how organized crimes uses the public procurement process in science. I will not name the cities, but you know, as I lived in both countries, I have heard stories that are chilling. We have to resist this and reorganize our societies along the ways that makes us competitive with others. Let's go back to the pure patent law in a way and talk about the patent protectability. So what can be protected by a patent? Novelty is required, and it must not be subjective novelty, as I have spoken yesterday about originality in copyright. It must be objectively new. And this is why we examine patents to determine if they are objectively new. We should, this what has been devised as a solution must not be obvious to a person specialized in art, as we say in patents. It must have inventive step, which is a European term for obviousness, as Americans call this inventive step. So it's almost easier to understand it in the American way, meaning if it's obvious to a person skilled in the art, it will not be patentable even if it is a novel thing. So there is this additional step required for an invention to be patentable. And then the third requirement, these three requirements are part of the Paris Convention from the end of 19th century. And the third one is the easiest to satisfy, and that is the industrial applicability. The invention must be industrially applicable. And the original intention in the 19th century was to exclude inventions in agriculture. It was thought that agriculture should not be, the idea of protecting, monopolizing things should not be applied to agriculture, but only to industrial activities. But our understanding of agriculture changed, and we consider agriculture industrial activity, and mariculture for that matter, you know, as well. So this is considered today everything except the perpetuum mobile, which is not feasible, not physically possible. Everything would be industrially applicable. And that's where we have changed this third requirement. So we speak, as I have yesterday mentioned already, about the true patent. And we have for the big patent, the true patent, the different kind of routes for applying for it. It can be global, it can be regional, and so on. We will talk about that specifically. Then we have the small patents, such as the utility model in Croatia, and then the petty patent in Australia, Gebrauchsmuster in Germany. And then in the US, there are some different solutions, such as, again, utility model, but different than European one, and the design patent, because US does not have a design right per se. They protect design by design patents, just to complicate life for everyone. I mean, but this is their 200 years old plus 210 years old solution, and they were not prepared to reform this yet. So it's a different system of protecting design in the US. There is a formal protection, rather complex and expensive. It is, sometimes I say that patent right is a right for adults, meaning adult entrepreneurs, that for someone who is new as entrepreneur will really have difficulty to digest complexities of patent protection. And this is, of all the rights, it's most important to have a proper strategy for protection, because otherwise you will be throwing large part of your budget away without the result or effect that you are aiming for. Again, the duration of the right is 20 years, and it cannot be extended. In a way, it is extended every year, because unless you pay so-called annuities, and in trademarks, this 10-year fee is called a renewal of trademark, the renewal fee. In patents, this yearly extension is called annuity. So every year of the life of the patent, except for some countries, first 2 or 3 years, which are paid through the filing fee with the patent application, domanda del brevetto, or patentni zahtjev, patentna prijava. We then pay at once when patent is granted. Then we pay the duration for 2 or 3 years, depending on the country, and then later on we extend it if it makes economical sense. So if we earn by practicing the patent, we will extend it. Otherwise, the patent will last 6 years, 7 years, 15 years. And if we stop practicing it, or we cannot sell the rights, or license the rights to its exploitation, it will lapse. It will not be extended. So this is some principle of self-cleaning of what is protected. We don't have dead wood on the register, as Americans call it, something that is not practiced anymore. That's the way with patents. Many people, today say that 20 years is too long, or that it is too long for some industries. And when Americans started protecting software with patents, which European Union rejected originally, but then allowed some forms of protection even for software inventions under the so-called doctrine of technical effect, where you can protect software if it produces a result in conjunction with hardware, which all software does. So we protect equally, only we write patents differently. So we have effectively software protection for patents. Then the Americans were saying, but the software patents should not last 20 years. The technologies in software are exploited for 3 years, 5 years, and then there's something new. So there was a lot of thinking about why does this right last for 20 years? And it was not reformed because, again, if something is not practiced, it's very likely people will stop paying the fees, so it will not be protected anymore. But the original 20 years was apparently, there is some theory about that, is from the time of guilds, when from an apprentice to a master in guilds as craftsmen, the craftsmen were going through these stages, 3 stages of education, which generally lasted 7 years. So the idea was that if someone as an apprentice would develop an invention so that he could exploit some of it through even when he becomes a master. And that's this is one of the theories, but it's not really clear why there is this 20 years, but just so that for you to have an explanation if you ever ask yourself why 20 years, And yes, and it is really a crown in any companies or institutions IP protection activity. You should protect all of your IP, such as copyright, your website, your this and that, your name, company name as a trademark, before engaging with patents. The fact that EU tells us, okay, now you focus on patents because it is so important for the EU, does not mean that you shouldn't be focusing on protecting other elements and structuring your portfolio in terms of other IP rights. The fact that you have a domain name, they will end up in the same IP portfolio with patents once you get to the patents. But don't skip protecting other simpler rights, because it is essential for proper functioning of a market entity in complex market for anyone. You cannot become adult without being a child. In other words, as I said, that patent is IP right for adults. So if you decide to obtain a patent rights, where do you go? And obviously, for Croatia, we still remember well time before we were in the EU. Then we were going to the national office. I mean, what is a Croatian patent? It's just a small territory, you know, one of the almost 200 territories in the world, or more than 200 by now, because we keep splitting in smaller territories, as we know. So there are more nations and more national offices. This is not very relevant, because if you have only a Croatian patent, you didn't achieve much. You know, someone will be able to practice your patent in Slovenia. Or now when we are in the EU and we have the EU patents, then this is, someone will practice in Kosovo, because EU patent is not an EU institution, as I said. So they will be able to have a Bosnian and Serbian patent, regardless of them not yet being in the EU, but they will not be able to have a Kosovo patent, because Kosovo is not recognized by all the countries and therefore cannot really become a part. And now there's a question whether Kosovo should become a member of the European Patent Convention. I don't know even how does that stand, but they cannot be part of the so-called Madrid Agreement. So Kosovo is a territory where you cannot apply for trademark through a Madrid Agreement, which is one of those international systems of application where you apply at a single place. Why? Because they are not recognized by the EU. Because Romania, Spain, Slovakia, of the EU countries are blocking recognition of Kosovo. And there are additional countries such as Russia, and I don't know who is blocking their recognition on the UN level. And the Madrid Agreement is a UN instrument. It is administered through World Intellectual Property Organization, which is a specialized UN organization, and they cannot be, so you cannot have a Madrid application for a trademark in Kosovo. I'm not sure where it stands again with patents, but you have to be aware that there will be different situations regarding the national, regional, and global protection, such as Patent Cooperation Treaty, which is a global equivalent administered by UN. Again, it's the WIPO that administers PCT, that is Patent Cooperation Treaty, just equivalent to the Madrid Agreement that you can apply for trademark. You can't say globally, but there are 150 members, you know, so it is a really large part of the world where you can apply for. There will be exceptions in South America. Argentina, for instance, is not a member of either PCT or Madrid, nor are they members of the Hague Agreement, which is the same thing for designs, where you can make one global application, but there is a huge difference between trademark, where you have 150 members of Madrid Agreement, with the situation in Hague Agreement, where there was only 16 members, and now it is above 60. I don't know how much, because people realize, the countries that is, realize the advantages of global integration, and they start adhering to this to these international mechanisms. Yet still, designs are not at the level of the trademark protection, which remains the globally best integrated field. And the PCT is also very strong and very persuasive, and many countries are members of PCT. Then what you normally do when you have the idea of protecting your rights, you will be advised by your patent agent or your attorney or your patent office, even if you try to do on a national level and go directly to them as a company, which is possible. You don't have to have a representative in most of the countries at your national office. So you can talk to them as if they would be your patent agents. And they will advise you to do a patent search. So today it became a standard that before applying for a patent, you do search. Search is a very, very interesting and different animals, again, so to speak, because you can do usability searches, patentability searches, landscaping. There are literally dozens of types of trademark searches. And already to make choice of a search is best to have someone advising you, to structure your search, and then to choose those who will perform the search is, again, nowadays you have search specialists. And only 10 years ago, many patent agents were performing patent searches. But patent searches became so complex that now we have specialists who will do only patent searches. And you have them in different flavors and varietals. Many of them will be in India offering budget services. Some of them good, some of them bad, some of them superficial and without the proper understanding of what you have instructed them to do. So you might be paying less, but you will sometimes get a decent result and sometimes you will not. Then you have people who will be twice as expensive or 4 times as expensive, sitting in expensive countries as Norway, and I'm talking about the real, companies providing services, or Netherlands, who specialize in a high quality searches, and they will be very expensive. Their services will cost almost as much or as much as patent drafting services. So you have to think about the spending from minimum of 1,500 to 2,500 for this simpler searches to $3,000 or $4,000 searching fees before you even start drafting your patent. That will cost normally from 3,000 to 6,000 in Europe, or for simpler patents, or up to 12,000 for more complex patents. And this is why I say that things in this field need to be properly budgeted. You cannot go around protecting any invention that you produce if you don't have budget for this. So if you have an average of 10,000, including search and drafting for an invention, and you have only $20,000 budgeted annually for IP, then you will be able to do one patent, because you also have to have a budget for other IP rights that, as I said, should not be overlooked, and not even thinking about the budget for enforcing patents. That is multiple of this. We are talking about 20,000 euro for enforcing a patent in a less expensive country. And if you go enforce patents in a country expensive such as UK or US, you have to count in thousands of dollars for the enforcement. So obtaining a patent is just a small part of using patents. You need to have enforcement patents, which obviously, if you are in science and you license out or make this transfer of rights after you patent it, you don't have to think about it. But if you go on your own into exploiting patent, then you need to think about all these other costs, such as enforcement, and not to speak about the annuities. And so the costs are huge. You know, these are. I was now recently speaking as a mentor on a startup incubator, and I said it is hundreds of thousands. And then one other mentor who was on that call said, "But why are you keeping it that low? It's millions. You have to have millions of euros budgeted if you want to use the patent system to its full advantage." So that explains, this idea of this being really an advanced right for adults again, so to speak. So once you do searches and you get the results, then you decide whether to apply or not. If there is a chance that the patentability search showed that you can obtain a patent right, you will go into drafting on an application, and then you will go into its filing. You need to set a timetable. Your timetables should be also on a strategic level. This is not ad hoc for a single patent, but people who are new to patents, they not only they don't understand that there's a strategy for setting, which patent will you apply for a second patent within 6 months or 9 months or 12 months or 14 months? How will you stretch your resources? This needs to be determined in advance, but the people don't understand that even if they have one patent, they have to plot next 3 months, next 6 months, when, which fees will be payable at what time, when will the part of the research team need to schedule their time for working with the patent agent. And these are dozens of hours over 3 months period, which is normally something that when you draft the patent is, at least in Croatia, we allow ourselves for 3 months, and then over these 3 months, we will have a multiple 2-hour or 3-hour sessions determining of how will this be drafted, and how much resources will be used by the inventor, how much will it be outsourced to an agent, and again, this will look different in different countries. And in Croatia, we have a specific problem, and that is that we don't have experienced patent engineers in sufficient number. We don't even have enough patent engineers in given technical fields. While we may have an experienced patent engineer who is a physicist by background and will be working in mechanical engineering and a little bit in electronics and so on, he will not be useful really in chemistry. Then we have another 3 or 4 somewhat experienced patent engineers in chemistry, because we have pharmaceutical industry in Croatia, and these people acquired necessary experience. But if someone new comes into field of chemistry, these people will have their time full. They will not be able to work with the newcomers. And they will work with their existing clients, just as these, guys who have mechanical or physics or mechanical engineering background will be working with their clients. And if there is someone coming into artificial intelligence, as I told you, I'm working now in artificial intelligence, there will be no experience whatsoever, because our industry they did not engage in patenting their inventions or even making inventions in this field. So small countries are very difficult, but the similar type of problems you will have even in big countries. And when I speak with my colleagues, as I have mentioned, in Paris, they have the same problem, only on a different scale, and they have more options and deeper resources, so they can do that. There will be only, like a few places on earth where this will be. One is the US, where they have this patent engineers with technical background, so they have many more lawyers who will be able to understand the technological foundations, underlying technology of the patent, and will be better at drafting it. And then there are points elsewhere, such as, for instance, in Munich, where you have a huge number of engineers because there is the European Patent Office there, and some other cities, such as London, or in Italy, for instance, there was a strong mechanical background in both Torino because of Fiat and Milano because of strong engineering companies in Lombardia entirely. So, I mean, going back 100 plus years, no, when they had started to deal. So there will be such centers of excellence. But when I was doing some marine-based patenting, which I did, and we were on a low budget because Croatian inventors didn't have really significant budget for that. Even in the US, to find someone with a marine background and not being, not having a tariff of $10,000 or $15,000, which is relatively easier to find, but to have below 4,000, which was our budget, was extremely difficult, So even although I lived in the US and had a lot of contacts there, I struggled for few months, 3-4 months, before we found someone with a specific marine biology knowledge who was able to draft a patent for this inventor that we were working with at that time. So we have, to build all this knowledge. It's not like you walk to any law office and you say, I would like to make a patent. People who will work there are likely not having an idea of how the whole thing works and how you need to organize yourself, whom to contact, how to get help. And again, in Croatia, we have, unlike Italy, that has a very well-founded and developed patent advisory consulting network. We don't. We have very few, and we have to bootstrap ourselves by working with some low-cost engineer in Munich, because we cannot produce that in Croatia, because we don't have this experience. So we have incredibly hard task, really, here to bring the level of IP protection to a proper level. But with patience and by innovative approach of how to work with, and I have described to some of this, how do we work with people in Munich, and how do we work? I mean, I started working mechanical engineering with people in Milano, because initially there was no knowledge in the early 2000s here how to draft the patents, even in the mature fields. And the same thing here is in the electronics, and obviously Croatia became really very strong and probably on average as competitive or more competitive than Italy with our IT scene, and the number of startups that we have now is, so it's crazy. I mean, to get these people first to understand they need to patent things, and then to provide them with patent services is extremely difficult. So this big dynamic of development is presenting a different kind of problems in themselves. So let's speed a little bit up. I gave you all this background just to see how demanding is to work successfully with patents. And again, in Italy, this will be much easier, because provided you have resources, and you will have them easier than in Croatia, meaning finances, you will have a mechanism which is well established and well developed to get there. In Croatia, you will have 3 steps more to get to your patent. So patent then proceeds, after you file it, to examination and then to grant. You deal along the way with documents, and there are tens of millions of patent documents. Someone says 30 million at this point, meaning present and past patents, the scientific articles. All this goes into searching. This is why searching is so expensive. And then in the end, there's enforcement. So some of the patent protection systems as examples are PCT, which I mentioned. There is the EPO, European Patent Office, based on the EPC, which is European Patent Convention. There is Eurasian patent application possible in the former US countries, USSR countries, excuse me. That is also quite developing quite well and is very functional. A lot of people are using it. Then there are African, former English colonial and French colonial countries, ARIPO and OAPI. I apologize, there's an I missing here at the end. There's ARIPO and OAPI. There is the international PCT application. This is the most successful global system for application, where you make one application and then you extend it to any country that is signatory that you decide to extend it. It is close to Paris Convention. It uses the priority date of the first application in the European Union, in the Paris Union sense. So if you are applying for first application in any Paris Union country, and again, there will be, almost whole world in there except Latin America mostly, and some other smaller countries scattered around the world, there you will have the priority date from that application. And all the terms will be calculated from that priority, plus your protection once you get the patent will be from that date. You have another feature in PCT, and that is the preliminary examination by International Search Authority Office. So there will be offices such as European Patent Office or US Office or many other important offices internationally who have high capacity of searching, will be providing you with an international search report. And this is called preliminary examination. And this will help you decide in which countries you want to enter. If you get a really bad report and you see that that you are not likely to get patents in many countries, and you should know this based on your preliminary search before the application. But here you will be able to check this, and then you will decide, if you will go broadly or more narrow with your extension to PCT countries. The mechanism is devised so to allow people to use the 30 months from priority date for commercial exploration of a patent invention. Think about this. Paris Union gives you priority of 12 months. So you go to Paris Union, make a priority in one country, and then you have to go within 12 months to any other Paris Union country, which is almost whole world except Latin America and some countries there, in order to get the priority date. If you miss the priority date, your patent will be valid in these other countries from the date of application, and you are likely, if you apply for it 18 months after the priority date, because on 18 months you will get publication of your patent. So after 18 months, your patent will not be new because it will be published in the priority countries, and for the whole world, you destroy your novelty. So you have this window of 6 months, after 12 months to 18, to apply because your patent is still secret and you did not destroy its novelty by publication of the patent application. You are not achieving that much because you will have the 6 months, but you still don't have real time to test the commercial viability of your patent. So you need to put funds into national patent extensions. And I know that your head is spinning because you know it's spinning to anyone who's not in the patent field. But in order to bypass this losing of rights, of gradual dissolving of rights under the time pressure of 12 plus maximum 18 months period, PCT was devised so to preserve the novelty for 30 months. Because 12 months is certainly not enough to test commercial viability of a product, but 30 months already is. And this is why the whole world is using PCT application system. So because of this 30 months in which you can negotiate and see if the market responds positively to your invention, and then you know if to make a big splash and spend tens or hundreds of thousands of dollars on the full national application process through PCT. I'm not going into detail of how it looks. This is partially what I have been deciding you, and regretfully this slide doesn't even much help of this, you know, getting out of the haze of all these dates. EPC is a step more than PCT, but it's limited in territory to the EPC member states, which are not, I repeat, not EU. It is also Turkey, Norway, Iceland, UK now, you know, even Serbia, Bosnia, and so on. So you can have the EPC extension states and the member states, but the system works in the extension states as well. And you have a single application like in the PCT. You have single application examination like in the preliminary search report, but in difference to PCT, this one is the only examination. In the PCT, you will at 30 months enter into national examination, and here at the end of the process, you will have only one examination in Munich, Hague, Berlin, or Vienna, where there are European patent offices. And after that, you will have, after that single application and single examination, you will have national rights in all the countries without further examination. So the difference between PCT is that the last examination there is done in the national offices, increasing the costs, while here this is reduced. But the fact is that you don't get a single EU patent right, like you get a single EU trademark or single EU design right. Here you will have national rights, and you will see the consequences of that when you want to cancel this right. Well, canceling EU TM, the EU trademark, you could do only in one place, and it will be canceled. While here, you have to go from country to country and cancel things. So if you cancel in Germany, you did not cancel it in Hungary or Croatia, you know. So there will be national rights with a simpler procedure of getting it. That's essentially what it is. then to remedy this, EU tried to do the UPC, the Unified Patent Court, that would be able to cancel true European patents. And the European Patent Office would at the same time be a European Patent Office for one right on the territory of the whole EU, and the European Patent Convention Office for the other countries. But we would have one European universal patent in Europe, and we were on the verge of achieving this when Brexit happened, and UK did not ratify the UPC before leaving the EU, and now we have the UPC, which says the English is one of the crucial languages, and that UK must ratify the convention in order for it to come into force. So after 40 years of efforts, we were already almost there, and then it all fell apart again. I will skip these details of patent protection. Also, we are getting closer to the end yes, we are getting there. So here you have more on what I have already mentioned, and this is that the novelty must be objective, and this is why we examine it. So it must be new in respect of the date of application, and this knowledge must not be contained in any databases, journals, presentations. It must be not part of the human knowledge. It must be really new. But to make things more complicated, it must contain inventive step, and it must not be obvious for a person skilled in the art from the appropriate field of the state of the art. This is incredibly hard to determine. Who is average person skilled in the art? How do you determine this? There are millions of cases, about which standard should it be applied for an engineer who should have known that if you combine document A, document B, and document C, that this is obvious. Who is that person? How do you determine this? And how do you determine this in the hindsight, which is American term, describing this? Because once you know that this should be done in that way, it's impossible almost to erase and go back to the situation of that person before the invention was made, And combining the three, was it obvious, or should it, or if it was not obvious to the inventor, how would it be obvious to an average person? And this is why we spent £200,000 in the UK to determine the validity of a patent and things like that. It's just monumental. You know what Americans say? Americans say that if the patent system would have not already existed, it would be irresponsible to introduce it. But now that we have it, it would be irresponsible to abandon it, because our economy works on the basis of this. So this monumental cost, really, to most of us in smaller economies, almost makes no sense, Scaling up to the level of the US or the global pharmaceutical giant, how will you do that as a, small manufacturer or a small shipyard on Korčula, How do you get into this game? So it's a big policy question for our politicians, what to do, how to deal with that in the future. It's it's something that we should keep in mind as we ramp up our patent ability to use the patent system. The process starts with application. It is the application will then contain application for the recognition of a patent, description of the invention, and it will have a claims of what has been described. So the claims of the patent, and we will look at that obviously tomorrow, because today we will not have more time to go into these details. So the claims are legal part of the patent. Description is the scientific part, which doesn't mean that there is no science into claims. The claims are really combined. It's a science articulated regarding the legal requirements. There are legal parts of the description as well, because the claims will be connected to the description in some way. They will be very tangibly connected. So I'm not going to go into that, how it works in court when you are enforcing patents, but interpretation of claims will definitely be based on the description of the invention. So interpretation of claims will be based on the description of the invention in a legally relevant way. So you don't put law only in the claims, you must think about it in the description as well. You have very often drawings that will be explaining what is teaching. That's the nice American way of saying the patent teaches you how to practice it. So whatever is described as a teaching of the invention will be explained through drawings. And there will be a part called abstract, which most of the unexperienced people start reading a patent at abstract, but stop there. Those who are experienced will read the abstract just to get a better feel of what is the field of the invention that is claimed there, but will then skip to the claims. So the real serious reading is of the claims, and that's where you start reading the patent if you understand the patent field. The patents are published during the process. And I will stop here, and we'll try to catch up tomorrow as I did today. And I will leave you to ask me anything or tell me what do you want me to address if I will be abbreviating tomorrow this part. What do you want me to address about patents? Let me hear you before we say goodbye.
No questions.
No. Good. Did you, for instance, these things about patents? No, I try to maintain a level of complexity that shows how thing is complex, but totally eliminating the true complexity. So how does it look to you? I mean, with your experience, does it look, you know, that it's too complex or
Not at all.
No.
Not at all.
Okay.
I teach innovation management at the University of Trieste, and I don't teach IPO because we have a lawyer that teaches IPO, and so I avoid, let's say, to mention IPO. I just mention IPO, for example, when I talk about strategies for appropriation of knowledge, or for example, when I talk about some topics that are always interesting for young students, like patent trolls and new trends, let's say, related to protecting from people that patents only for offensive reasons, let's say, so part of the strategy. But I'm not an expert in the field, and I was able to follow everything. Actually, it was even quite, I would say, simple.
Okay, so there's one example on the Italian side of showing, you know, where Italy is with the understanding of the whole system. Is that like that also in Croatia? Is there someone who is also teaching innovation here, or you know, how does it look to the Croatian side? No, we will never know. Good, good. If there is no comments, I will not insist beyond the time. But so I will stick to this level of complexity, from which I am afraid that some participants might feel like dizzy from this. But it is really, when you talk with the patent specialists, it gets crazy complex. You know, no one can really understand what we are talking about. So that's how it is. I am trying to keep that middle road. Any other question or wish for me to address anything in specific? No? Well, then back to Lana. I am then done for today, and we'll see each other tomorrow.
Thank you very much for everything. We will see you tomorrow. It was wonderful today.
Yes,
Look forward
okay.
to tomorrow.
I am happy. Thank you very much for the compliments. I appreciate that very much. Thanks.
Thank you very
Bye-bye.
much. Bye.
Mladen, see you in Trieste
you.
for a
Thank
glass
you.
of
Bye.
wine.
See you tomorrow. We look forward to it.
See, yes, thank you. Yes, I mean, you know, Guido, I didn't catch who else was commenting, but I am all the time in Italy, so that might be, you know, that might be a real possibility.
Let's go in Nosmica for a glass of wine.
Exactly. We can meet also in the wine cellars up on Carso behind. Good. Okay. Thanks. Bye.
See you tomorrow.
Bye-bye.
See you.
Thank
Bye.
you. Bye. See you tomorrow. Bye.
See you all.